The judge is basically saying, if you two can't sort out getting together and talking, then I will intervene.
Yeah, the judge made it pretty clear that she seemed to be in the position that she was going to weigh in favor of the SEC here in enforcing their subpoena. It's very rare for the SEC to get a no-show on its subpoena, like Elon did earlier this year. It's very rare for them to sue to enforce that subpoena, and it's even more rare for the SEC to lose in court on a bid to enforce a subpoena.
Okay, so chances perhaps aren't on his side for this. He does feel, though, that he's already answered an awful lot of questions, not once but twice. Is there any sort of, well, context to this where we've seen people have to come in and give evidence time and time and time again?
There's a lot of situations when in an SEC investigation, they ask more questions. The facts of this investigation, which is one of a number into Elon Musk's companies, go back to his purchase of Twitter when he bought up a large stake when the company was private. And so they interviewed him close to his purchase of Twitter. And then earlier this year, they did their investigation. They talked to a whole lot of people, and they wanted to come back to Elon and say, hey, we have some more questions. Let's sit down and have a conversation and get your testimony here. And basically the SEC said that he played catch me if you can and tried to play fast and loose with the location and then move the date, and the SEC just kind of got sick of it. But it's fairly normal for them to go back to what they would think is a key witness, the CEO, the guy who bought the company eventually, and ask some more questions after doing their investigation.